Paul Jackson.
Yes, ma'am.
And this is cause number 26 DCCR 0112. Mr. Jackson was previously in court, entered a plea of guilty to aggravated robbery. There was no agreement in this case. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. State has, Judge.
Are there any additions or corrections?
Not from the defense. Not from the state, Judge.
All right, Mr. Rojas, you may proceed.
Thank you, Your Honor. I realize, Judge, we've got a problem with guns in this county, and more specifically in the city. I don't know that anything we do here today is going to solve that problem. Certainly, there are things you can do to deter other people watching this and see what happens to young people with guns. But I think there are some people who are not going to learn their lesson until they go to prison and spend a certain amount of time there. There are some people who are going to go to prison and never going to learn that lesson. They'll just spend their life in a revolving door, coming into court, prison, in court, and back to prison. And there are those that, for whatever reason, the circumstances they find themselves in their life, they make bad decisions, make mistakes, and are deserving of a second chance. And I think that's the category we find Paul in this morning, Judge. I think if you look at the letters that were written on his behalf, he was raised by his mother and his grandmother. He lost his mother. I think he was 15 when she passed away. His life went into a downward spiral from there. Just lost hope. Didn't see any reason for continuing on. Got involved with some bad people, and made some bad decisions. But I don't think that those decisions or what he's done in his life on that one day are irreversible. I don't think that's something that should cause him to go to prison for a certain amount of time and have a felony conviction on his record and come out possibly worse than he is today. As far as the incident reports, all the incident reports that are negative happened prior to the plea. I think there's an incident report that happened recently I think he hurt his knee or something else.
Yeah.
That's nothing bad against him, I don't believe. He's a 17-year-old kid. If he's allowed to be out on probation, he's going to go back and live with his grandmother. He's got a good support system. You can see from the letters. He's got family that'll help him out. I don't know that. I think if you're going to give him probation, I think probably ISF would be a good conditional probation. As I said, he's 17. I don't think he can go to ISF until he's 18. He doesn't turn 18 until July, so I would assume still be in jail until his birthday, and then if that frees up in ISF. So he's not going straight to the street right now if you were to send him to ISF. I've spoken with Paul every time I speak with him. He's kind, respectful. I just really think this is a kid who made a bad decision on that one day, and I don't want that to ruin his life. Speaking with him, he is remorseful. He's sorry this happened. He asks about the two kids, the victims of the case, and he wants to issue apologies to them, and hopefully they're not too traumatized by what happened. But again, Judge, he's just asking for a chance, and I really think he deserves a chance. This is a kid that doesn't need to go to prison. If you look at his life before his mom passed away, apparently he was doing good in school.
Attention then turns to the firearm involved in the case. The prosecution notes that it was assembled from a kit and lacked identifying markings that would normally connect it to an owner. This detail is presented as another reason the offense should be viewed with greater concern. The argument continues that a young person possessing such a weapon raises serious questions and adds to the overall gravity of the situation. For all of these reasons, the prosecution asks the court to impose a sentence consistent with similar cases that have come before the bench. After hearing both sides, the judge thanks counsel and addresses the defendant directly. The judge notes that these cases are never easy to decide and acknowledges that everyone involved understands the difficult circumstances surrounding the hearing. The courtroom grows quiet as the judge prepares to explain how the final decision will be reached. The defense explains that after the loss of his mother, the young man faced a major change in his life. His attendance at school declined, and he eventually had to move into a different educational environment. According to the defense, this difficult period affected nearly every part of his daily routine and future direction. They argue that the event created a deep emotional setback, but also believe his path can still be corrected. The request before the court is simple. Give him an opportunity to prove that he can rebuild his future and make better choices moving forward. The prosecutor responds by acknowledging the defense position, but states that the facts of the case carry greater weight. He explains that while there are circumstances that may deserve consideration, the seriousness of the offense remains the central issue. The prosecution argues that the factors increasing the severity of the case are far more significant than those offered in support of leniency. The court is reminded that the offense involved an armed robbery carried out alongside another individual. A 16-year-old victim lost his phone during the incident, while a young family member witnessed the entire event unfold. The prosecutor emphasizes the lasting emotional impact such a frightening experience can have on a child who was present during the encounter.
And I'm sure you're aware of all of that. I find your case a little bit different than some, but not the guns are the biggest concern for me and for everyone. And the using them in a way like it's no big deal and everybody having them at 15, 16, 14, whatever. I appreciate the fact also, though, that you've never been in trouble. As a juvenile, you've never been in our system. You figured out real quick that you need to follow the rules in jail, because I'm sure word got out there people are talking about the fact that is something that really affects me and what I do. And so I appreciate the fact that you've gotten your act together out there. And I'm talking because I don't know what I'm going to do with you right now, because I don't disagree with either attorney here today. And that puts me in a position where I've got my job is two things. Is one well, more than that, really. One is to protect our community. Another is to punish. Another is to rehabilitate. It's something where I have to potentially take chances that makes me sometimes uncomfortable. It looks like that before your mom passed away, you were doing really well in school, playing basketball, right? And that's a hard thing to go through, especially at your age. But you can't let something like that get you where you are now, right? What would she want you to be doing? Not this, right? So does grandmother live in the same neighborhood where all this took place?
The judge continues by asking about the defendant's living situation and whether his grandmother lived near the area connected to the case. The discussion then turns to how close he was to the apartment complex involved in the incident. After establishing that he lived only a short distance away, the judge gives him a chance to speak for himself before the court reaches a final decision. The defendant takes that opportunity to express regret and offers an apology to those affected by the events that brought everyone into the courtroom. After listening carefully, the judge announces that a decision has been made. He explains that he is prepared to offer an opportunity for a different future, but makes it clear that the chance comes with serious responsibilities. The judge warns that this decision is based on trust and that he expects that trust to be honored. Instead of imposing a lengthy prison sentence, he chooses a path that allows the defendant to remain in the community under strict supervision. The court explains that the probation terms will be extensive and that any violation could expose him to the full range of penalties available under the law. The judge stresses that the consequences of breaking those conditions could be far more severe than what is being imposed today. He reminds the defendant that a different outcome was very possible and that a significant prison sentence was under consideration. The message from the bench is direct. This opportunity should not be wasted because a return to court under similar circumstances would likely lead to a much harsher result. The judge emphasizes that the goal is success rather than failure and points to the family members present as proof that people still believe in his future. The court then formally accepts the guilty plea and finds sufficient evidence to support the conviction. However, the proceedings are delayed to allow the defendant to complete a lengthy period of deferred probation lasting 10 years. In addition, the court orders a financial penalty and requires several months in county jail before probation begins. Following that period, he must enter and successfully complete a structured program designed to improve judgment and decision-making skills. The judge explains that the purpose of the program is to help him develop better habits and avoid choices that could place his future at risk. He is reminded that adulthood is beginning now and that life will require a different level of discipline from this point forward. While others around him may make their own decisions, he will have to follow a stricter path because any failure to meet the court's expectations could completely change the direction of his life. The warning is firm, but the message is also hopeful as the court makes clear that this is a rare opportunity to build a better future before more serious consequences become unavoidable.
They may or may not. So you're starting off your early adulthood very different, and you either make a conscious decision to change and grow up and be mature about it, or you end up in prison. It's that simple, right? Once you get out of ISF, you'll live with grandmother. I'm going to order that you are ordered to live with her at her house until I order otherwise. So you get a job, you want to get your own place, you want to go live somewhere else. You don't get to do that without my permission. So you don't get to go hang out other places. You're home every single night. You will have a curfew. If you're not there and you're caught not home when you're supposed to be, you're right back in here and you could go to prison. So I'll do what I can to put the rules there. It's up to you to follow them. Make sense? Obviously, a condition of your probation is that you are not allowed to have any firearm at all. You cannot have firearms at your disposal. So if there are firearms at grandmother's house, they either have to be under lock and key or removed from that house. I can assure you, if you get in trouble with a gun again, it's really not going to be good. Okay. This is your chance. I hope you take it and this changes your life, because this type of probation that I just gave you means you do not have a felony conviction on your record. So if you have a felony conviction, it changes your life really bad in a lot of ways. You can't get certain jobs, you can't go to certain schools, you can't live certain places, even apartments. Sometimes they don't let convicted felons live there. So you don't have a felony conviction right now. But if you violate, you're back in and you do. So you kind of have a clean slate. It's up to you to keep it that way. Okay. I'm handing you the trial court certification that shows this was an agreement. Well, there was no agreement, actually. You do have some rights to appeal. You can talk to Mr. Rojas about that.
Judge, I would ask that the court consider making a condition of his probation, no contact with the co-defendants.
Yes.
And I was looking for the names of those co-defendants, and I can't find them.
It might be in here. So, Mr. Jackson, you are to have absolutely no contact, no communication whatsoever with Dale McDonald. Okay. And also obviously no contact, no communication with the victims in the offense. You're not to go near that street or their house. So if that's the way you normally get in and out of the neighborhood, you've got to find another way to go. You cannot be anywhere near that area. Do you understand? Okay.
Judge, there was a third subject who was, or co-defendant who was unidentified at the time of the offense. I think that in Mr. McDonald's case, there was at least an identification made. Information as to that third individual. I don't have that in front of me.
So whoever the third guy was, and we'll get their name, you can't be around him as well. And that doesn't mean just in person. Like y'all can't send each other messages on DMs or anything like that. You understand? Okay. All right. Go back with the bailiff.
Thank you, Judge.
Good luck to you, sir.
Yes.
I've got the first two. Are you good? Mm-hmm. Did you already do it?
There's 2 of 19
I know.
time.
Hey, ma'am, are you Ebony Broussard? Yes, ma'am. And will your client, it's my understanding she's going to just enter pleas unagreed on the motions. Raise your right hand the best you can, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you. You can put your hand down. Will your client waive the formal reading of the motion in each of the cases? Ms. Broussard, in cause number 19-32518, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 21st of 2020 for the third-degree felony offense of escape while arrested, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am, it is.
And then in cause number 19-32806, I also have a motion to revoke your unadjudicated probation.
The hearing then shifts to a detailed review of the defendant's prior probation cases. The prosecutor carefully walks through the record and confirms that one case involved an offense against a law enforcement officer which resulted in a 10-year deferred probation beginning in early 2020. The defendant acknowledges that the information is accurate. Attention then moves to another case involving possession of a controlled substance where a 5-year deferred probation was imposed in 2021. Once again, the defendant confirms the details without dispute. After establishing the background, the court begins reviewing the alleged probation violations one by one. The first allegation states that the defendant committed a new offense involving public intoxication in January of 2026. The defendant openly admits that the allegation is true. The next allegation concerns possession of a controlled substance on the same date. Once again, he accepts responsibility and confirms the accusation. The questioning continues as the court addresses another allegation involving possession of an illegal substance. The defendant acknowledges that claim as well and clearly states that it is true. The court then reviews an allegation that he was under the influence of an intoxicating substance during the same incident. The violation occurred. As the hearing progresses, a different issue is raised regarding court-ordered financial obligations. Unlike the earlier allegations, the defendant initially disagrees and states that he is not currently behind on his payments. The court then reviews the records more closely and points to documentation showing that at a specific point in time, he owed a substantial amount in unpaid fees. After hearing that information, the defendant clarifies his answer. He explains that the balance was indeed overdue during that earlier period, but says he later made the necessary payments and brought the account up to date. This exchange highlights the difference between the historical record and the current status of his obligations. By the end of the questioning, the court has received admissions to several significant probation violations while also gaining clarification regarding the payment issue. The atmosphere in the courtroom becomes increasingly serious as the focus turns from establishing the facts to determining what consequences may follow from the repeated violations that have now been placed on the record.
That was true in February, but I've caught up on it.
Okay.
I said I was $22 behind.
Oh, February.
February, you were
Oh,
behind.
yes, ma'am, that was true.
February.
In cause number 19-32806, count 5 alleges as of February 2nd, 2026, you're $965 behind. Is that true?
Yes, ma'am.
And then in cause number 21-36615, the allegation in count 5 is that as of February 2nd, 2026, you were $555 behind. Is that true?
Yes, ma'am, that was true.
Did you enter your, and we'll get, when we come back, we can get the actual amount and where she is on with an updated report. Did you enter your pleas of true to counts 1 through 5 in each case freely and voluntarily?
Yes, ma'am, I did.
And did you plead true to all of those counts because they're actually true?
Yes, ma'am, I did.
All right, then in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty in each case and revoke your probation. However, I'm going to order an updated report from the pre-sentence probation department, and then we will come back at a later date for sentencing. Obviously, anything that you think is important for me to know, get that information to Mr. Kimler, and he'll present it to me on your behalf when we come back.
Yes, ma'am.
A bit reluctant to do that out of her conditions that she was under the influence of intoxicating substance, particularly PCP.
Already set bonds.
Oh yeah.
There was a request and they were set in each case. I'm not going to modify those amounts. All right, we'll see you back at sentencing. Anything? Yes, ma'am.
Just
Hang on just a second. Go ahead.
just because these officers have been here this morning, I would just like the opportunity to ask if they have anything with respect to Ms. Broussard. I know Ms. Richard as a supervisor is here and has diligent notes on it, if there's anything that they feel is important for the court to note at this point, or would you rather wait?
I would rather it be either in the update or come then, because in 6 weeks, I'll probably have forgotten what we talked about.
No, that's fine.
I appreciate y'all being here. I'm sorry this one ended up last, but yeah, let's just get an updated report, get everything you need in there, and then if there's any other testimony, we'll get that at those sentencing hearings. Thank y'all for being here.
May I just ask, in the instance that she were to make those bonds, would there be anything that you all would recommend with respect to?
They're $100,000 in each case. There's a GPS and a drug patch already ordered. Anything else that y'all would want? I figured that would cover it.
Yeah.
All right, thank you. You can go back with the bailiff.
Yes, ma'am.
Oh, I'm sorry, she needs your thumb. Good morning, are you Jaden Worlds? And Mr. Parker, will your client waive the formal reading of the indictments and the motions in each case?
Okay.
Mr. Worlds, in cause number 26, DCCR 0361, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from January 21st of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Give me just a second. And then in cause number 26, DCCR 0415. Many button. You're charged with a first-degree felony offense of aggravated robbery, and that's from January 27th of 2026. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, those two cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each of those cases.
Objection.
It's admitted in each case. Is there any evidence that Mr. Worlds is not competent?
No, Your Honor.
All right, sir, in cause number 26, DCCR 0361, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding in that case of a deadly weapon. In cause number 26, DCCR 0415, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with that agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm also making an affirmative finding in that case of a deadly weapon. Now, in cause
The court then turns its attention to 2 additional probation cases that were placed before the judge for review. Records show that the defendant received deferred probation in late 2024 for unauthorized use of a motor vehicle. A second case from the same period involved fleeing from law enforcement while operating a vehicle. Both cases carried 5-year probation terms, and the defendant confirms that the information presented by the court is accurate. With the background established, the hearing moves to the alleged probation violations connected to these matters. The first allegation in both cases centers on a serious incident that took place in January 2026. The court references the same event that had already been discussed earlier in the proceedings and asks whether the allegation is true. Before moving further, the attorneys briefly discuss the numbering of the violation counts to ensure the record is clear and accurate. The conversation focuses on which allegations apply to each case and how they should be addressed during the hearing. Once those details are sorted out, the court returns to the substance of the violations. One allegation states that the defendant possessed and used a handgun during the January incident and that shots were fired toward 2 individuals. The court carefully reviews this accusation and asks for a direct response. The defendant admits that the allegation is true. The second probation case contains a matching allegation tied to the same event, and once again, the defendant confirms its accuracy. With those admissions now placed on the record, the judge seeks confirmation that the pleas were entered knowingly and voluntarily. The court wants to ensure that the defendant understands the significance of the admissions and the potential consequences that may follow. By this stage of the hearing, several major probation violations have been acknowledged, and the focus is no longer on determining what happened, but rather on deciding how the court should respond. The atmosphere becomes increasingly tense as each admission adds weight to the proceedings and brings the defendant closer to a decision that could have a lasting impact on his future. The courtroom remains focused on the next stage of the case as the judge prepares to evaluate the full scope of the violations and determine the appropriate outcome.
In 1420 and 1 and 5 and 1721 freely and voluntarily.
Yes.
And did you plead true to those counts because they're actually true? I have also here on the tablet some documents in those 2 cases that have your signature on them that the state's marked as Exhibit 1. Did you also go over these with Mr. Parker? And do you understand them as well? And you also understand if I follow these agreements, you'll be waiving or giving up any right to appeal. State tenders number 1 in each of those cases.
Objection.
It's admitted. All right, Mr. Worlds, in cause number 24, DCCR 1721. Find that you entered those pleas to counts 1 and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time finds you guilty of the state jail felony offense of unauthorized use of a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1. Hold on, I just pulled the wrong one up. What's the agreement on?
2 years TDC and 2 years state jail.
Gotcha. So in cause number 24, DCCR 1420, also find that you entered your pleas of true freely and voluntarily. Find counts 1 and 7 true. Find sufficient evidence at this time to find you guilty and find you guilty of evading arrest or detention with a motor vehicle. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. In all of these cases, I'm going to hand you the trial court certifications that shows that these were agreements that I followed, and so you have waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Here you go. Hey.
The discussion then shifts away from the underlying allegations and focuses on procedural matters involving bond status and upcoming court dates. The judge reviews the current situation and confirms that the immediate issue before the court relates only to the newest criminal case. As the conversation continues, attention turns to the bond amounts that were previously set and whether they accurately reflected the seriousness of the circumstances. During the exchange, it becomes clear that concerns had already been raised about the bond level connected to the robbery case. The judge recalls earlier discussions and notes that the amount appeared unusually low given the defendant's existing felony probation history. The court explains that situations like this can sometimes occur when important background information is not immediately visible during the initial bond review process. According to the judge, some officials handling early bond decisions may not always have access to complete probation records at the time they make their determinations. The court suggests that this may have contributed to the outcome in this particular case and indicates that efforts are being made to improve the system so similar issues can be avoided in the future. Rather than making an immediate ruling, the judge decides that additional review would be beneficial. The hearing on the request to increase the bond is postponed for 1 week so both sides can further examine the relevant documents and prepare any necessary arguments. The court explains that this additional time will allow everyone involved to better assess the circumstances before a final decision is made. Discussion then turns to the defendant's custody status. The court confirms that bond has been posted in the robbery case, but not in the separate probation matters where bond amounts were also established. After clarifying the situation, the judge concludes that the only issue requiring attention at the next hearing will be the request concerning the robbery bond. With that matter resolved, the court officially resets the hearing for the following week and prepares to move forward with the next case on the docket. As the proceedings continue, the judge calls the next individual forward and begins transitioning the courtroom's attention to a completely different matter waiting to be addressed.
Okay.
Are you Francisco Garza?
Francisco Garza.
And this is 25 DCCR 1623. I'm going to take judicial notice of the court's file. Mr. Garza was examined by Dr. Capon for competency to stand trial. I've received that report dated April 21st of 2026. The finding in his report is that Mr. Garza is currently not competent to stand trial and that inpatient treatment for restoration of competency would be warranted at this time. Is there any other evidence with regard to competency?
No, Your Honor.
No, Judge.
All right, then at this time, I am going to find, based on that report, that Mr. Garza is not competent to stand trial. Order inpatient competency restoration treatment for a period of not to exceed 120 days from the date he gets to the appropriate facility, and then we will await a report from them at that time. You're going to go to a hospital so that they can get you where you can understand everything. Okay, Mr. Garza, you need to cooperate with them. All right, and then we'll get you back here to go through your case. Okay, you can go back with the bailiff. You're Alethea McDonald. Is that your name? And this is clause number 26 DCCR 0348. And Ms. McDonald was evaluated for competency to stand trial by Dr. Capon. I've received that report dated April 21st of 2026. The finding in his report is that Ms. McDonald is currently not competent to stand trial, and inpatient treatment would be required for competency restoration. Is there any other evidence with regard to competency?
No, Your Honor.
Not from the state, Judge.
All right, then at this time, I'm going to find that Ms. McDonald is currently not competent to stand trial. Find that inpatient treatment is necessary for competency restoration and order her to the appropriate facility for a period of not to exceed 120 days from the date she gets to that facility for competency restoration. All right, you can go back with the bailiff. You can go to the back.